Hello and welcome to my channel. I'm Leanne Newton and this video is part 2 of this week's recap. So if you haven't watched part 1 yet, I highly recommend doing that first. You can also check out my threads on X, which were written in real time. My username is KiaraJ2001. I am not a US attorney. I am qualified in UK law. Everything I say is my personal opinion as someone who understands and interprets the law. It is not intended to be legal advice. Video and subscribe to my channel. You can also press the notification bell to be alerted to future content. So, the other things that happened last week are Blake Lively filed a motion to compel against Wayfarer. Stephanie Jones filed a motion to quash Wayfarer's subpoena to Edgeworth for information related to Jones' works. And the big news. Wayfarer responded to Jones's motion to quash by asserting the crime fraud exception to the attorney-client privilege. Jones then replied to Wayfarer's opposition, and Steve Sarowitz and his family experienced attempted arson at their home and extortion under the threat of kidnapping his daughter. So, firstly, we've got Stephanie Jones' motion to quash the third-party subpoena. Jones tried to assert every privilege known to anyone with a law degree. I can't see them working because Wayfarer's request is fairly reasonable given the circumstances. The scope is later confirmed to be limited to this case. It is information that is definitely relevant to the cases against Jones, Sloan, Lively, and the New York Times, and possibly Reynolds, depending on what is produced. But it could also be relevant to Jones's case against Abel and Wayfarer. We finally learn that some details about a subpoena, but it's not that subpoena. There's a line in the paragraph that reads, subsequent to that conferral, Edgeworth produced responsive documents in its possession to Jones' works solely for the purpose of Jones' works reviewing and assessing for privilege. Now, I find it fascinating to see Jones asserting a right that she was only too happy to deny the Wayfarer parties. There is a footnote where Jones is having a bit of a tantrum because Wayfarer had the audacity to serve a subpoena on a third party for information when she was only too obliging to play a game of sham lawsuits and fake subpoenas as a third party herself. I'm not sure what her issue is with this, as Edgeworth is, in her own words, complying with a lawful subpoena. And if you listen to Jones's filings, even from a few days ago, Edgeworth would have no choice and would have to comply as there is no alternative for them. That is how Jones pleads her position with the subpoena she was served by Lively. Yet here, she displays a remarkable knowledge of the legal system, specifically around subpoena obligations. Jones confirms that Wayfarer narrowed the scope of their subpoena, but Jones still isn't happy. It sure sounds like there's something in there that she's afraid of coming out, like evidence that she was accessing Jen Abel's communications for months, or the mystery paperwork that she ambushed Abel with and never provided a copy of to her. Jones' work suggests that Wayfarer is obliged to seek information from Jones' works and not the third-party provider. Wayfarer will have subpoenaed the same information from Jones' works in the same way that they subpoenaed Marvel for information that they also requested from Ryan Reynolds. Jones says that subpoenas under Rule 45 are not meant to provide an end run around the regular discovery process. However, Neither are sham lawsuits that are designed to get around the notice requirements of a subpoena. Jones asserts the work product privilege. This is pretty much a repetition of the attorney-client privilege objections. Jones is claiming that she hired Edgeworth because she was considering litigation over defamatory websites and social media accounts that were created about Jones' works. Jones has not initiated litigation on these matters, and again, the data from Abel's work issued phone will be relevant to Wayfarer's proceedings. I don't see how Jones can claim attorney-client privilege applies to discovery selectively in a lawsuit that doesn't exist to prevent its production in a lawsuit that currently exists, and it is the heart of the entire network of lawsuits. Jones hasn't explained how information regarding Abel's communications could be related to any litigation regarding defamatory websites and social media accounts. It should be easy enough to separate out the relevant communications from anything unrelated to this lawsuit. Abel was not dismissed for any reason related to defamatory websites and social media accounts, so at this point I can't see why there would be any issue producing information related to Abel's termination and the subpoena Lively served to obtain the communications from Jones' works. So we now have Wayfairer's opposition to Jones's motion to quash. I'm going to briefly summarise the sequence of this filing as presented to the judge because it is a masterclass in how to logically present an argument to a judge. Wayfarer starts by asserting the crime fraud exception to rebut Jones's assertion of the attorney-client privilege. Wayfarer then recants the claims against Jones and the sequence of events on the day the phone was confiscated. False imprisonment has also re-entered the room. Wayfarer then ties Jones's admission and statements to the facts that Jones has, by her own admission, accessed Abel's communications and had them forensically extracted. Wayfarer is now connecting the communications to Lively, Sloan, New York Times, and setting up the reason why the Van Zandt lawsuit was necessary. Wayfarer then delivers a striking blow with all of the details of the Van Zandt lawsuit and the filings attached to it on the docket. Now, this is the first time that this would have been formally put in front of the judge, the Van Zandt lawsuit and subpoena. So this is quite an important moment. Wayfarer also points out all the various reasons why it is implausible that Van Zandt could be connected to Wayfarer in any way. They then continue to explain how the lawsuit is a sham, how the lawsuit facilitated the information being shared with Lively, specifically for a second time, given that they're alleging that Jones had already given it to Lively before. And Wayfarer asserts that they have still not had sight of this particular subpoena. They've seen lots of subpoenas, but not this one. Wayfarer then continues to explain why they believe the lawsuit is a sham and how the subpoena deprived them of notice or rights to attempt to quash, effectively abusing the legal process. They also allege that Lively was deliberately hidden as a plaintiff and had no intention of actually litigating any of the claims in the Van Zandt lawsuit. Wayfarer begins to explain the information being sought by the Edgeworth subpoena and why it is relevant. They talk about the receipt, use, and disclosure of the communications to Lively and the lack of integrity. Wayfarer begins to explain the information being sought by the Edgeworth subpoena and why it is relevant. One quote that was in there that I really liked was this. Jones Works did not object to the sham subpoena, but instead blithely surrendered the entire contents of Miss Abel's stored communications a second time to Lively without Miss Abel's knowledge and to fabricate a protection of legal process. So Jones then filed a motion to respond again. The judge granted this. So Jones didn't try to explain the allegations surrounding Van Zandt Inc. and the subpoena. I expected her to do that, but she did not. This is what she did in her motions to dismiss, so I really shouldn't have been surprised. She avoided the allegations and pretended that they were not in the counterclaims. And then she did that here. She briefly made a reference, which I will get to in a minute. So Jones is quite ballsy enough to accuse Wayfarer of, quoting here, litigation by ambush. Despite her own admission that her motion to dismiss, she didn't bother to give Wayfarer notice of Lively subpoena. Jones claims that Wayfarer has effectively conceded that attorney-client privilege applies by asserting the crime-fraud exception. Now, that is not what happened. She asserted a privilege, and Wayfarer merely said they didn't agree it applied, but they asserted a relevant exception for good measure. That is standard. Jones claims that Wayfarer has not connected their arguments to any of the allegations, but that is what the discovery is being sought for, and I suspect that is why Jones is fighting so hard against the Edgeworth subpoena. Finally, Jones refers to the filings from Van Zandt and has a bit of a grumble that Wayfarer has not connected Jones Works to them, calling the suggestion wild. Now, I can't believe she's going there. Jones Works will be connected once she hands over the subpoena, which she still fails to do. And on top of that, Lively's attorneys have already confirmed that it was the same subpoena that they served on her. So for me, this is just Jones grasping now. Jones then claims that the allegation of colluding with Lively to get a subpoena in a case that Lively had no intention of litigating falls short of a fraud corrupting the administration of justice that could sustain the exception. And that's a little quote that she says that I put here on the slide. Now, I completely disagree that the method that Lively obtained a subpoena and that she served on Jones falls short of anything considered fraudulent. The subpoena came from a lawsuit that used a false narrative to obtain information by deceptive means. That is the textbook definition of fraudulent. So we also had Lively filing a motion to compel Wayfarer. This was the third party, non-party subpoena responses. They're overdue, and Lively is asking the judge to compel them to respond. It is as simple as that. The responses sought are from third parties who are not parties to these lawsuits. So they are employees. One of them is definitely, I know, an employee of Wayfarer, but she is not one of the parties in the lawsuits. I'm not going to go much further than that. The responses are filed under seal, so I don't have the information to talk about them in any depth. Lively does also, in this request, asks for a breakdown and evidence of Wayfarer's financial loss. Again, this is something that they will hash out. This is quite normal. The judge will decide on how things need to proceed. But Lively wanted information about Baldoni's text message regarding his neurodivergence, and I put the response here up on the slide. The responses in red is from Wayfarer. These are documented notes from the meet and confers. So when Wayfarer challenged the request for information regarding Baldoni's neurodivergence, it's Wayfarer alleged that this had not been brought up in the lawsuit, to which Lively allegedly claimed it was in the discovery. Now, Wayfarer points out that discovery has not yet taken place in this lawsuit, and that it only appeared in Van Zandt's discovery improperly in a case that was unrelated to Justin Baldoni, because Lively is referring to one of the text messages or emails that was in amongst the communications from Jen Abel's phones. So Wayfarer then challenges Lively to explain to the court how the law firm managed to obtain medical information regarding Baldoni, whilst also explaining why they believe it's relevant to Lively's claims. The actual quote, I'll read it because it's funny. But so the actual quote that Wayfarer said is to Lively's lawyers was, "If your firm wants to explain to the court how your firm obtained information concerning Baldoni's purported medical condition and attempt to explain how it is relevant to Lively's claims, we welcome the opportunity to respond thereto." I thought that was quite snarky. However, the other issue I have is Lively submitted this as part of her motion to compel. And I cannot get my head around the fact that her lawyers thought this was a good idea to send this to the judge. Then Wayfarer filed an opposition to Lively's motion to compel. The overall gist is that they believe Lively is being unreasonable, so there's no great surprise there. Wayfarer accused Lively of filing the motion to compel to generate a fabricated headline for the media. They say that Lively is falsely claiming that they are not producing records to justify their loss claims, whilst also acknowledging Wayfarer is prepared to produce documents pertaining to reasonable requests. In any case, Wayfarer alleged that there is not a need for this information right now because the case is not at the stage where they are needed. My own speculation is that Lively could be seeking these now to consider settlement talks, but I am not stating that's what's happening here. I don't know. It's just a thought that occurred to me. Wayfarer points out that Lively has also not produced any documents, and her counsel has not explained how she searched for documents that they have collected from Lively but have not yet produced to Wayfarer. Wayfarer points out that Lively has the option of notifying them and arranging a further meet and confer if she believes that production is not complete. Wayfarer states that Lively has not explained why she declined to do this, given the high number of motions from the Lively parties and Jones collectively on the docket, which is burdensome for the judge as well as Wayfarer. Wayfarer calls into question the need for information surrounding the net worths and tax returns of the individual Wayfarer parties to quantify damages. Wayfarer highlights that if Lively ever gets around to identifying the information she is seeking from the tax returns, that was their words, they will be able to look to see if it can be produced by a less intrusive source. And that's a reasonable thing for them to say. Wayfarer rightfully points out that Lively does not clarify anywhere in her letter why she needs responsive documents that concern the liquidation of assets that relate to the movie. What was not raised in this was the response to the information request around Baldoni's neurodivergence. Now, my thoughts on why Wayfarer didn't bring this up is that the words on the meet and confer record, the email in the previous slide, which was attached to Lively's filing, it speaks for itself. Wayfarer don't need to add any more to it, and the judge is now aware of the bans and subpoena, so less is more in this instance. There was an attack on Steve Sarowitz's family. They were threatened. Someone has been arrested following an attempted arson attack at the home of Steve Sarowitz last week. They also accessed the phone numbers of his wife and daughter. There was a threat to kidnap Sarowitz's daughter as part of an effort to extort $80,000. A link was made to the lawsuit against Lively with one of the text messages stating, "If you fail to comply, we will take your daughter hostage and she won't make graduation. At that point, we will ask for more money if you guys are prepared to spend $100 million to ruin the lives of Miss Lively and her family. We are sure you can spare a few for your daughter." Now, this is obviously disgusting, and it was disappointing not to see Lively come out and denounce these threats being made in her name. Regardless of any personal position on this case, no one should be getting threatened or harassed by anyone. That's obviously applies to the parties and their attorneys, but also people who put in the time and effort to explain the cases, break down the legal aspects, and keep the public informed. It also applies to people who exercise their free speech rights by commenting and sharing opinions on the case. This should not be happening. Moving on to something positive, though. My friend Ludwig the Sniffing Dog, who is on X, has illustrated and animated impressive music videos recently, where his friend Kirby has written and sings amazing songs which are about the Wayfarer Lively case. I'll put a link in the description, but I highly recommend you go and check them out. Their collaborative work is really uplifting to see, and the songs are so catchy. And then finally, yesterday I joined my friend Lauren from Court of Random Opinion on her live stream from the pub in a truly British style. We talked about some of the filings that have come out this week and added our trademark humour, so please go and check that out too. I will leave a link to Lauren's channel and yesterday's video collaboration in the description. That's all from me for now. I'll be back again next week, probably with another two-part video recap, given the way this week has started with the filings. This week, I know we've got Jones's responses to Wayfairer and Abel's oppositions to her motions to dismiss due on Thursday, and Lively's response to Jed Wallace's amended complaint in the Texas lawsuit due on... No, that's due on Friday. Sorry. Jones's responses are due on Thursday. But we could be getting a flurry of a lot of other responses, so I'm not even going to try and, give a definitive, this is what I'm expecting. I know there's filings due on Thursday, there's filing due on Friday, but I imagine we will see various responses to all the letters and motions to compel and quash that we have seen in the last few days. So thank you for watching, and I will see you again soon.